and this court are a joke.
All right, everyone, please take your seats. Before we begin, I need you to understand something. I don't speak like this often.
Let's not pretend this matters. My father will shut it down, like
Wait,
always.
wait, lady, let me finish. That moment right there, that's when this case stopped being ordinary. Because in this courtroom, people usually sit quietly when a judge speaks. They listen. Some are nervous. Some are scared. Some already know they're in trouble. But that day, the woman standing in front of me wasn't nervous at all. She was smiling, not confused, not worried. Smiling. She leaned back slightly, arms crossed, eyes scanning the room like she'd already won. Like this was just another inconvenience someone else would handle for her. And when she spoke, she didn't lower her voice. She didn't apologize. She didn't hesitate. She dismissed the court. I've been doing this job long enough to recognize the difference between fear and confidence. And this wasn't confidence. This was entitlement. The kind that doesn't come from strength, but from believing consequences have an off switch. Now understand this clearly. This courtroom exists for one reason: to protect people, not reputations, not bank accounts, not powerful last names, people. And when someone walks in believing they're immune to that responsibility, the law has to respond. What struck me wasn't just what she said, it was how easily she said it. Like she'd said it before, like it had worked before, like authority was something she could talk over instead of answer to. At that moment, I knew this case wasn't about a minor mistake. It wasn't about misunderstanding a rule or pushing a limit too far. It was about someone who genuinely believed the system would bend the second her father's name entered the room. And here's the thing most people don't realize. When arrogance shows up in a courtroom, it doesn't make things better. It makes them final. Because the law doesn't argue with attitude. It corrects it. By the time this case was over, there were no smirks left, no interruptions, no crossed arms. What began as certainty ended in silence, and the sentence that followed made something very clear, not just to her, but to everyone watching. Money can delay consequences. It cannot cancel them. And the moment I finished saying that, the room settled. Not because I raised my voice, not because I threatened anyone, but because this courtroom runs on rules, and everyone inside it knows that when those rules are ignored, things move fast. I didn't explain myself for long. I didn't need to. In this room, you listen. You speak when you're told to speak, and you answer for what you did. You don't bring your father's influence in here. You don't bring wealth. You don't bring confidence. You bring your actions, and they speak for you. Most people understand that immediately. You can see it in their posture. Shoulders tighten, eyes drop, hands come together. They realize this is real. She didn't move. She stayed relaxed in her seat. One leg crossed over the other, head tilted slightly to the side. And for a brief second, she looked down at the table in front of her. Not at the court, but at her own nails, like she was checking something unimportant. That's when I knew. Calm does not mean uncertain. Calm means control. And control means I was already paying attention to every small thing she did. Every glance, every breath, every sign that she didn't take this seriously. This courtroom exists because people get hurt when rules are ignored. Not in theory, in real life. Streets, sidewalks, neighborhoods where people expect to be safe. When someone treats the law like a suggestion, the risk isn't abstract. It's immediate. I watched her look up again, and this time there was no smile, just impatience. The kind that says, "How long is this going to take?" She leaned slightly toward her attorney and whispered something. I didn't hear the words, but I didn't need to. The timing said enough. She believed this was still a conversation she could control. That belief is dangerous, Because when someone refuses to respect the process doesn't argue back. It closes in, quietly, step by step. And right there, before a single charge was read out loud, before any facts were laid on the table, the outcome had already started forming. Not because I was angry, not because I was offended, but because she still didn't understand one simple truth. This wasn't going to be talked away, and what she had done was about to make that very clear. I lowered my eyes to the file, then looked back up at her. This is usually the moment when things turn real. Names do that. Details do that. For most people, confidence fades right here. I read her name into the record. Her age, 23. Young, yes, but old enough to understand rules. Old enough to understand danger. As I spoke, I watched her closely. No worry, no apology, just that same steady look, like she was already planning how this would end. Then I said her father's name. That's when her chin lifted, shoulders back, a quiet breath through her nose. She expected movement. She expected the room to react. She expected that name to carry weight. Her father is a powerful man, a CEO, the kind of man whose calls usually get answered, the kind of man used to fixing problems, quickly and quietly. But here's the truth. None of that mattered in this room. I didn't pause. I didn't explain myself. I made it clear that influence stops at that door. Because what mattered wasn't who raised her. It was what she chose to do. And that choice wasn't small. It wasn't paperwork. It wasn't a technical error. It was a decision that involved speed, streets, and people who never agreed to be part of her confidence. People who were one moment away from being in the wrong place at the wrong time. I saw it register then. Not fear. Irritation. Her jaw tightened just slightly. Her fingers pressed into the edge of the chair. She didn't like, where this was going. She didn't like that her name wasn't changing the tone. She leaned toward her attorney again and whispered, quicker this time. I still didn't hear the words, but I saw the impatience, the belief that this was taking too long. That belief told me everything I needed to know. Because when someone treats risk like a game and authority like a delay, the court has no choice but to step in. I closed the file and, met her eyes. At that point, this case was no longer about status. It was about an act that could have ended very differently. And from there on, the outcome wasn't a question anymore. It was already set in motion. It began 3 months earlier, on a clear afternoon, in a place where nothing dramatic is supposed to happen. She was driving through a residential neighborhood, not a highway, not an empty stretch of road, a neighborhood, the kind where dogs are walked on short leashes, where kids ride bikes too close to the curb, where older neighbors step out to grab their mail without looking both ways every time. The speed limit there is 25. She was going nearly 70. Not a momentary push on the gas, not a mistake. She stayed fast, cutting through that street like time didn't matter, like the road belonged to her. At one corner, a ball rolled from a front yard toward the street. It stopped just short of the curb. If it hadn't, whoever ran after it would have had no warning. An officer saw her and pulled her over. A routine stop, the kind that usually ends quietly. A ticket, a warning, a lesson learned. He walked up and asked a simple question. Did she know why she was being stopped? She didn't apologize. Then she said it. Calm, certain, like she'd used it before. Do you know who my father is? That sentence changes the meaning of everything, because now this wasn't about speed. It was about power. It was about telling the law that it should step aside. It was about saying the danger she just created didn't matter as much as her last name. The officer stayed professional, He explained the risk. He explained the law. He explained how close this came to hurting someone who never agreed to be part of her day. She laughed, quietly, just enough to show she didn't believe a word of it. He did his job. Reckless driving, excessive speed, public hazard, each charge written down, each one earned. Most people would leave shaken. They'd replay that moment. They'd think about how close it came. She didn't. She drove away irritated. Not scared, not reflective. Irritated that her afternoon had been interrupted. And standing there in that courtroom, reading what happened line by line, I understood something with complete clarity. This wasn't about how fast she drove. It was about how close she came, and how little that mattered to her. From that moment on, consequences weren't a possibility. They were unavoidable. At that point, this case should have been finished. Most people, after a stop like that, go home quieter than they arrived. They replay the moment. They think about how close it came. They drive slower the next time. She didn't do any of that. Instead of reflection, she reached for her phone. Later that same day, she posted about the stop online. Not to explain, not to apologize. She turned it into entertainment. A video, a joke. She mocked the officer who pulled her over like he was part of a story she controlled. She smiled. She laughed. She spoke like the law was an inconvenience, not a warning. And people watched, thousands of them. I didn't need a long explanation to understand what that meant. When someone does that, they're not learning. They're doubling down. They're showing the world that the risk they created didn't matter enough to slow them down. That was the moment my concern hardened. But even then, this could have stopped. One bad decision can still be corrected. One act of arrogance can still be addressed. Then came the second incident. Just 3 days later, she was back in the same neighborhood, same streets. And once again, she was driving too fast for a place like that. Not a small push over the limit. Enough speed to make it clear nothing had changed. This time, there was no officer standing there. There was a doorbell camera, mounted quietly on a front porch, time-stamped, clear. Her vehicle passing through too quickly for a street where people expect safety outside their own homes. That's when a mistake becomes a pattern. I remember reading that report and pausing longer than usual. Not out of anger, out of disappointment. Because warnings only work when someone is willing to listen. She had been warned. At that point, leniency was no longer a question. Education had already failed. Patience had already been tested. What remained was responsibility. Because when behavior repeats that quickly, in the same place, under the same conditions, luck is no longer a factor. It's running out. And once the court sees that, clearly, it has no choice but to act. Before the next near miss becomes something no sentence can undo. By the time all of that was on the record, the atmosphere around this case began to change. Not in the courtroom, outside it. It never happens loudly. There are no threats, no demands. Influence doesn't work that way. It arrives quietly, a call here, a message there. People asking questions that don't need answers. I was told her father was worried. Those words are familiar to me. They always mean the same thing. Someone believes this can still be softened, that it can be, delayed, that it can be shaped into something smaller. Then came a suggestion that made everything clear. Maybe the court could take more time. I stopped it right there. No delay. I made it clear that this case would proceed on schedule. No extensions, no pauses, no special consideration. The rules would apply exactly as written, exactly as they would for anyone else. That was the moment my patience ended. Not because I was angry, but because I recognized what was happening. The danger had already been documented. The behavior had already repeated. And now the pressure was shifting away from responsibility and toward convenience. That's not something a court can accept. I looked back toward her when that decision was made. She was still calm, but it wasn't the same calm as before. Her eyes moved more often now, scanning the room instead of settling. Her foot tapped against the floor, once, then again, before she caught herself. She felt the shift. For the first time, the pace wasn't hers to control. The system wasn't bending. And the people she expected to step in were no longer doing that work for her. I've learned something over the years. When influence fails, accountability takes its place. Quietly, firmly, without debate. The more pressure came from the outside, the clearer my duty became inside this room. This was no longer a case that could be adjusted. It wasn't something that needed smoothing over. It was already moving forward. They were in motion. Once it became clear that influence wasn't going to work, the focus shifted. Now the request was, mercy. Her attorney stood and spoke the way good attorneys do. Calm, careful, respectful. She didn't deny what happened. She didn't argue the facts. She asked the court to look forward instead of backward. Those arguments matter, and in many cases, they carry real weight. I listened. I always do. Leniency is not weakness, but leniency only works when someone accepts responsibility. I looked at the defendant while those words were being spoken on her behalf. She wasn't looking at me. She wasn't, nodding. She wasn't reacting at all. Her eyes were fixed straight ahead, jaw tight, like this was something being negotiated around her, not because of her. That's when the auctions narrowed. This wasn't about a single bad decision anymore. It was about everything that followed. The mocking, the second time through the same streets, the quiet pressure from the outside, the repeated belief that this could still be controlled. You don't offer mercy to behavior that already ignored a warning. You don't gamble with public safety just because someone has never faced consequences before. I thought again about that neighborhood, the ordinary people who lived there, the ones who never agreed to be part of her confidence or her impatience. They weren't sitting in this courtroom, but they were the reason it existed. And that's when the decision became clear. This court does not exist to protect comfort. It exists to protect people. When those two things are in conflict, the law doesn't hesitate. I felt the room change as that reality settled in. The air grew heavier. Even her attorney paused, sensing that the ground had shifted. The defendant moved in her seat, not annoyed now, controlled, waiting, as if the outcome was still undecided. But it wasn't. By that point, I wasn't weighing possibilities anymore. I wasn't considering alternatives. The pattern was complete. The risk was proven, and the responsibility was unavoidable. The only thing left was to make sure the sentence carried enough weight to stop this from ever happening again. And that decision had already been made. Once that decision was made, there was no reason to delay. I looked down at the file one last time, not because I was unsure, but because words spoken here don't fade. They follow people. They shape what comes next. Then I looked back at her. This is the moment most defendants finally understand where they are. Faces change here, breathing slows. I could see it in her. The confidence didn't come back. What replaced it wasn't anger or tears. It was disbelief, the kind that freezes you in place. I began with the facts, not emotion, not opinion. Reckless driving, excessive speed in a residential neighborhood, creating a public danger, a second incident after a clear warning. Each charge stated plainly, each one supported. There was nothing left to argue. I explained the purpose of what came next, not to lecture her, but to be clear for everyone listening. Punishment is not about anger. It's about protection. It's about stopping a risk before luck finally runs out. I told her a warning had already been given. She ignored it. I told her leniency had been considered. It was denied. I told her the court could not rely on chance to keep people safe. Then I imposed the sentence: custodial time, real time, time under supervision, without freedom to walk away. Her driver's license would be suspended for a period long enough to matter. Driving is a privilege. She had shown she couldn't be trusted with it. There would be financial penalties, not to humiliate her, but to reflect the seriousness of the risk she created. And there would be a community service, placed where consequences are real, not theoretical. As I spoke, the room went still. She stared straight ahead. Her jaw tightened once, then settled. It was the first time I saw it, realizing there was nothing left to negotiate. For the first time since this case began, she listened. Because once a sentence is spoken, belief no longer matters. Status no longer matters. Only what happens next does. And what came next was unavoidable. Not this time. Before I closed the record, I said only what needed to be said. I told her the sentence was not meant to end her future. It was meant to interrupt a path. Consequences had been set, and from this point forward, responsibility was hers. I explained her rights, calmly, clearly. She had the right to appeal, the right to speak with counsel, the right to challenge what had been decided. That's how the system works. Fairness does not stop at sentencing. She nodded once. Small, controlled, no words, no reaction. That was enough. I thanked the officer for doing his job professionally. I acknowledged the attorneys. No speeches. No extra commentary. Everything that needed to be said had already been said. Then I closed the file. The bailiff stepped forward. Chairs shifted. Papers were gathered. The courtroom began to move again. Quietly, procedurally, final. Court was adjourned.